Ladies and gentlemen, it is 6 o'clock, so perhaps we should start. It's really an honor for me to welcome you here this evening, those of you who are here in person and also those of you who are watching us online. So this is for the panel discussion facilitated by Justice Majid and with Sandy Liebenberg and David Bilchitz. Now, Sandy Liebenberg, just a few words. She holds the Oppenheimer Chair at Stellenbosch University, where she's also a distinguished professor. And she used to work here at UWC, of course, at what was then the Community Law Center. And it's great to have you back here again, Sandy. David is the director of SciFac, also at the University of Johannesburg. And we know David, he hasn't worked here, but we know him from his prolific writings on constitutional matters, also on animal rights, of course, which is also a topic I like, so perhaps in future we could have a serious discussion about that as well. A few words about Justice Majid. He's one of our most famous alumni of this university. He completed his BA Law and LLB degrees here in the early 1980s. He's, of course, a justice in the Constitutional Court now, previously in the Supreme Court of Appeal. He was recently appointed as honorary professor at UWC, and I hope I will be forgiven for saying this, but he's the best appointment we've made since I've been dean. We don't pay him a salary, but he works harder than many other professors in the faculty. So the topic tonight, the protection of socio-economic rights, and specifically the substantive content of socio-economic rights, or the minimum core, is of course a very important topic for various reasons. It raises constitutional issues about separation of powers, specifically about the role of the courts vis-a-vis that of the legislature and the executive. It also raises issues of enforceability and of methods of interpretation. And then in a broader legal philosophical sense, it raises issues about identity, about reason, about subjectivity, and also about justice. So we're looking very forward to the discussion about this tonight. So to end off, I know this is a welcome and not a thank you, but I want to thank, while I have this opportunity, the Dullah Omar Institute, specifically Ibn Yezid Durujai, will do the thank you later on this, and for the role that he has played, and his team at the Dullah Omar Institute, and also the administrator in my office, Cheryl Davids and Shlansa Mutsanani, specifically for their role here tonight. So with that, Justice, I'm handing over to you. Thank you.
Yeah. Good evening, everybody. I'm not really a professor. I'm a wannabe professor, so they call it an honorary professor. They make you work for free, and then they tell you it's an honor, and then when you're in the thing, I said, you got yourself into the wrong thing now. And so as a professor, I would usually stand here and present, but would you mind if we sit, if we do this? You don't, no disrespect intended. And I think it's just going to be easier for all of us, because I think we want us to be informal when we do this. I would first like to say that, and I said to them when I wrote to them in the mails that at least people will listen to real professors tonight, not a wannabe professor. But just to go back to last year, October, when I was invited to do the Dean's Distinguished Lecture, I chose a very risky topic about the Constitutional Court's approach to the enforcement of socio-economic rights, and I asked the question rhetorically. More or less paraphrased, is the court on the right track in its approach to the enforcement of socio-economic rights and the question of minimum obligations, amongst others. And in that talk, I sketched the history of the court's jurisprudence that you'll remember from Grootboom, and the dialysis case, Subramoni and the residents of Industry House and so on, where the court firmly said no to the concept and the idea of imposing a minimum core obligation when it comes to the enforcement of socio-economic rights. Now, the court has faced vehement criticism for that, and in my lecture last year, as a good constitutional court judge should do, I defended my colleagues. That first court and the ones that came thereafter, and I explained why we went that route. But I also referenced my judgment in Tubakhale. It's a judgment that you may be familiar with. It's a judgment I'm very passionate about. It's a judgment that I feel. And this morning in the classes I presented for the undergrads on separation of powers, I explained to them the doctrine of precedent. And I said to them that doctrine means that as a court, even as the highest court, you must respect your own judgments and follow them, because one of the fundamental tenets of the rule of law is the law must be certain. So that if you've decided a case on a certain set of facts, if you get a similar set of facts, you can't deviate from that precedent unless you as that court think the judgment is clearly wrong. Other courts are bound by it whether they think it's wrong or not, the SCA and the high courts and so on. And I said to them tongue in cheek, and I said they mustn't quote me, but I still think I'm right in Tubakhale. I'm bound by the majority. But I think Tubakhale raises the question of quo vadis for socio-economic rights. And tonight, I thought, as I promised in the lecture, I will invite real professors, but B, also eminent proponents of socio-economic rights enforcement. And personally, I don't mind saying it here, I've also said it to them privately, is two professors in this field that I have very high regard for. Sandy and David are well known to those of you who follow the discussions and the discourse on these topics. Sandy I knew from before at UWC. You would know that she's closely associated with this university for a long time, until 2004, with the Women's Rights Project and also the Socio-Economic Rights Project. And David I met in all places at Oxford last year, and the rest is history. We've actually become quite close, and as a man that you mustn't just look at him like that, he actually organized the conference for over 600 delegates at UJ, and it was a roaring success. I went with the Chief Justice there when he opened the conference. Well done, David. And so I'm very pleased that they've said no to me. People often say that they've said yes to me. People often say no to me. And thank you for saying yes. And why they are here this evening is, I said during my distinguished lecture that I'm going to encourage to have those who have views opposite to mine and the courts to come and talk, as we should in academic discourse do, to have those that hold a different view to come and talk on the topic. And we're going to have a follow-up after this on 14 August. Again, it's a Monday. Just make a mental note of that date. My retired colleague Johan Vroneman, who's also written on the topic and has sat in cases on the topic, will come and speak with Nozamo Zondo, who I'm pleased to say is here. Nozamo, where are you? Here, right in front of me. She's the head of CERI, Socio-Economic Rights Institute, an NGO which does wonderful work. And I'll tell you, at the Constitutional Court, if it hadn't been for these NGOs like CERI and others, and also in the high courts like Mfari Nkwazi and Cape Town and so on, that bring these cases to court. I mean, we are reactive. We can only work with what comes to us, and so it's up to them to bring the cases. And I want to commend you, Nomzamo, not only for the wonderful work that you do, but also commend you for saying yes to me when I asked you to come in August. So it'll be her with my colleague, Justice Vroneman, to follow up this conversation. And tonight I'm going to encourage my colleagues. It's not often that you can get to attack the court while a judge is sitting here, so please feel free and go for it. Tell me why we are wrong so that you could have this discussion and move it forward. And I think it's very unfair. I'm saying this tongue in cheek, but you be the judges. The academics criticize us all the time, but we don't criticize them. We sometimes quote them, but we never criticize the academics. But in all seriousness, I think constructive criticism is good. And last year I was at Dublin at an international constitutional conference, and I said there a lot of chief justices were there from old Commonwealth and existing Commonwealth jurisdictions and eminent professors. And I think we as judges, especially in an apex court like the Constitutional Court, should have far more close interaction with academics, because they shape the law, and it's important that we also have this discourse. We may agree to disagree, but it's important for us to have that interaction, and I have promised myself that I will continue doing this. And with all that mouthful, please feel free to ask questions afterwards, and feel encouraged to criticize the court, as long as it's constructive. I mean, one of the cases I dealt with in my lectures this morning is obviously the controversial Valus case, because I dealt with separation of powers in the context of substitution orders, where the court makes substitution orders that the decision maker should have made themselves. The one thing that I think we forgot to mention is that David here clerked with former Chief Justice Langa. So he understands the court, and he must explain to me why he hasn't persuaded Chief Justice Langa, who's late now, why he hasn't persuaded Chief Justice Langa to jettison this thing of rejection of minimum core obligations. That's the question I would like to ask him, because he was a law clerk there in his chambers. And so, I don't know, they have worked out who's going to go first and how they're going to do this. I know we may have time constraints, but judges only ask questions and write judgments. Professors like to talk, so I don't know if I have the powers here to tell them to stop, but I would like us to have as much time as possible to discuss this very important topic. Boss, let me end off by saying that I have no doubt when people ask me, what are the cases in your court that for the next 5, 10 years, I won't be there any longer, I'm counting the months until my retirement. But what are the cases that will come up increasingly? I think it's the land question. I think it's civil political rights, but more important, it's going to be enforcement of socio-economic rights. The question of when is progressive realization no longer progressive? When is reasonableness no longer reasonable? I'm stealing the thunder, but let me leave it there. I think it's a very, very burning topic. Nomzamo will tell you how many cases they get where people clamor for their socio-economic rights, their so-called second-generation rights, and where government says, well, we've got resource constraints. And so over to them, I don't know who's going to go first. I think, in all fairness, ladies first. So Sandy, over to you. Let's go there. Yeah.
So, good evening, everyone. Thank you very much to the Dean of the Law Faculty, Professor de Ville, to Ebenezer and Gladys of the Dullah Omar Institute, and especially to you, Justice Majid, for initiating this important conversation on socio-economic rights jurisprudence, following on from your Dean's distinguished lecture last year here in October. And as you already indicated, and you told David and I that please don't hold back, and that in your own words you have a thick skin. So I think you'll probably find that we've taken you at your word on that, but hopefully in a spirit of constructive criticism. So I'm going to focus my presentation this evening on what I see to be the purposes of socio-economic rights, the role of the courts in enforcing them, the reasonableness standard of review, and why I think the way the court currently deals with reasonableness is mistaken, and then also a word about resource allocation decisions and review of resource allocation decisions by the court. I hope I'm audible at the back there. Great, thank you. I'm not going to focus much on the minimum core debate, because I know this is David's, where he's going to place his emphasis, but I do have some things to say about that and how it fits into the model I'm going to be proposing, and I hope maybe in a session we can get to that. So my starting proposition is that TAC and the socio-economic rights jurisprudence specifically of duties imposed by sections 26 and 27 has been on a downward trajectory, particularly since the 2009 judgment of the Constitutional Court in the Mazibuko case. And in my view, this trajectory reached a low point with the majority judgment in the Tubachali case, which Justice Majid mentioned, which was handed down in 2022, and in which, in fact, Nomzamo and Seri were the main litigants of this case and know it much better than I do. So in this judgment, the majority, a narrow majority of one, penned by Justice Jafta, with the concurrence of the Chief Justice then Mogoeng and Shiki J, held that constitutional damages could never constitute an appropriate remedy for socio-economic rights violations because they conferred no rights on any individual. In fact, the judgment effectively downgrades the socio-economic rights in sections 26 and 27 to the status of close to a directive principle of state policy. In other words, they impose general duties on the state, and these duties are enforceable by the courts only in very limited circumstances. Justice Majid penned the minority judgment where he confirmed that constitutional damages could indeed constitute an appropriate when effective remedy. And fortunately, due to a separate concurring judgment by Justice Madlanga, the precedent of Justice Jafta that constitutional damages could never constitute an appropriate remedy for socio-economic rights violations is not binding law. So constitutional damages do remain available under limited circumstances. Some would argue that the flaw that set our socio-economic rights jurisprudence on this downward trajectory was already present in the reasonableness model of review which the court adopted in Kruitboom and TAC. What I hope to convince you of this evening is that I believe that reasonableness review can still serve as an effective basis for adjudicating socio-economic rights, but only with a fundamental reorientation towards the normative goals of socio-economic rights. And without this reorientation, I fear that we are approaching a point where these rights will be incapable of playing a meaningful role in helping to counter the current drift we are seeing in governance away from South Africa's transformative project. So I want to turn next to pose the question, what are the normative purposes of socio-economic rights, and what do these purposes imply for the nature of our constitutional democracy? So as is the case with all human rights, rights require a process of interpretation. And this interpretation is inevitably situated within the history, the current realities, and the future aspirations of an interpretive community. In other words, articulating the purpose of a right, such as socio-economic rights, requires an ongoing process of meaning-making, which is linked to past, present, and future. International standards can be helpful in this process of interpretation, but they also require, in the words of the legal anthropologist Sally Engel Mary, a process of contextualization and localization to be responsive to the context in which they operate. So how has the Constitutional Court itself attempted to describe the purpose of socio-economic rights? I turn again to Justice Majied's judgment in the Tubachali case, where he described the purposes of socio-economic rights as being both remedial and transformative. The remedial purpose of socio-economic rights in the context of the facts of the particular case, in this case the right to housing, he saw as integrally connected to correcting the spatial injustices caused by apartheid and colonialism, and requiring decision makers in the housing sphere to take into account the trauma of removal and resettlement. And in the prior Mshlangu judgment, which had to do with domestic workers' entitlements to social security, Acting Justice Victor and Justice Mhlantla in their judgments referred to the transformative purposes of socio-economic rights in terms of disrupting the intergenerational transmission of disadvantages on grounds of race, gender, and class. So these recent articulations of the purposes of socio-economic rights locates these rights at the intersection between South Africa's past, present, and future. They require us to redress the consequences of past oppression and also to recognize and redress current manifestations of economic and social injustice for the benefit of both present and future generations. As Justice Fruneman observed in his concurring judgment in Daniels v. Scribante, the values of the Constitution are not aimed solely at the past and the present, but also the future. He went on to observe that we may reach a point, a stage in South Africa where the distribution of property rights is no longer tainted by the racial inequalities of the past. Nevertheless, a future Mrs. Daniels, trying to eke out a living with minimal assets and income, will still be entitled to live a dignified life, no matter the race of the owner. Now, as is well known, the history and the remedial purposes of socio-economic rights is inextricably linked to the dispossession of land, the confiscation and destruction of cattle, and the devastation of the traditional ways of lives and livelihoods of traditional communities. This has been effectively demonstrated, amongst others, by Tembeka Ngukatobi in his book Land Matters. And the struggle for social, economic, and cultural dignity and equality was integral to the liberation struggle. We see it as a golden thread throughout all manifestations, both in the Congress movements and the Pan-Africanist movements, in terms of asserting the fundamental land rights and the socio-economic dignity of all. Documents such as the African Claims document of 1942 had very powerful articulations of social and economic rights. And this understanding of our history and the way that civil and political struggles for liberation were intertwined with socio-economic struggles is reflected in the holistic Bill of Rights of our Constitution. So unlike many classic liberal constitutions, our constitution recognizes socio-economic rights. And moreover, a conscious decision was made not to cordon off socio-economic rights into a separate section of the Bill of Rights called Directive Principles of State Policy, which would essentially be unenforceable by courts. Instead, the courts have the mandate under Section 38, read with Section 172 of the Constitution, to enforce all the rights in the Bill of Rights. So what can we learn from this history about the choices made regarding socio-economic rights and their place in our constitutional dispensation? And I want to suggest three things. The first is that socio-economic rights and civil and political rights are, as human rights scholars well know, mutually supportive of each other, and that we deny an aspect of our full humanity when we negate the importance of one set of rights. So without the civil and without the socio-economic goods and services for a dignified life, many civil and political freedoms become merely formal entitlements, stripped of their real emancipatory potential. Conversely, by treating economic and social rights as simply material commodities, without recognizing the civil and political dimension of these rights, we fail to recognize people's agency and dignity in the process of defining and implementing these rights. Secondly, this constitutive of the nature of South Africa's democracy. As expressed by Professor Carl Clare, the inclusion of socio-economic rights reflects an understanding that political democracy and social and economic democracy are inextricably linked and mutually constitutive. And so it is telling that Section 7.1 defines the Bill of Rights in the Constitution as a cornerstone of democracy in South Africa. Thirdly, what we learn from this history and the nature of our Bill of Rights is that it can help infuse substance in the notion of transformative constitutionalism, which some critics have maintained is an empty slogan. The holistic and integrated conception of our Bill of Rights signals a commitment to dismantling all forms of oppression across all spheres of human endeavor: civil, political, economic, social, and cultural. I turn next to examine the specific role of the courts in enforcing socio-economic rights in the light of this history and the purpose of socio-economic rights. So, Justice Majiedt, I think there can be little quibble with the notion that it is the state's primary responsibility to respect, protect, promote, and fulfill the rights in the Bill of Rights, including socio-economic rights. Indeed, the text clearly makes clear in Section 26.2 and 27.2 that it is the state that must take the measures to achieve the full realization of the right. The state has the legislative, executive, and administrative power to adopt the legislation and policies and programs through which these rights are defined and implemented. However, the virtues of legislative and executive decision-making in this sphere, so arguments courts not straying into the lane, such as institutional legitimacy and competency of the legislature and executive, compared to the vices of judicial decision-making, such as that courts shouldn't stray into the lane of the legislature and executive. They shouldn't disrupt the rational and equitable distribution of resources by these branches of government, are often presented in very abstract ways, divorced from the realities of contemporary political decision-making in many societies, including South Africa. These arguments tend to elide the reality of legislative and executive dysfunctions, corporate and elite capture of democratic institutions, and the formidable obstacles facing those living in poverty from achieving accountability for socio-economic decision-making through traditional political processes. I quote again Carl Clare. He says, whether, for example, the legislature is representative and plays a democratic, let alone a progressive role, are matters of contextual judgment on the historical record. Process failures happen. Legislatures have been known to ally with forces of reaction, to be captured by wealthy interests, and to be so dominated by an entrenched oligarchy as to lose touch with the grassroots. On the other hand, arguments in favor of a deferential role for courts in socio-economic rights tend to understate the contribution that good socio-economic rights adjudication can make to affirming the dignity and agency of impoverished communities, deepening democracy, and improving government decision-making. For example, the judiciary can bring an independent, reasoned consideration to bear on disputes affecting fundamental rights, which the political process has either ignored or been unable to resolve. Good public interest litigation can stimulate more direct forms of accountability for socio-economic rights decision-making, thereby enlarging participatory democracy. And the constraints of institutional competence and polycentric consequences can be ameliorated through good quality evidence, including expert evidence, the participation of amici curiae, the joinder of parties, and so forth. So I think these arguments tend to fall into an artificial trap between civil and political rights and economic and social rights, which the court actually in the early certification judgment warned us against, that we should not simply see civil and political rights as policy and resource neutral and only make judicial intervention problematic when it comes to economic and social rights. So by this, I'm not trying to make an argument that the courts should ignore their own institutional constraints and ignore the primary role of the legislative and executive. I think these institutional constraints do have to be taken seriously. But what I think is not helpful is broad brush generalizations as to the strengths and weaknesses. And I think it will always be a case of careful and contextual judgment as to whether litigation is appropriate in a particular case and what kind of judicial intervention is appropriate. So my argument is that judges should both advance the substantive purposes of socio-economic rights, while being sensitive to the institutional dynamics that affect their practical realization in various contexts. The first prize should always be for the courts, not for the courts to make socio-economic rights policy, but rather to stimulate the state to act consistently with the relevant constitutional rights. I turn next then to the infamous reasonableness model of review to ask whether this model is capable of doing both these things that I have just sketched out. So as many of you know, reasonableness review has deep roots in the judicial review of administrative action, and it aims to accord primary decision makers an appropriate latitude or margin of discretion to make policy and legislative decisions. Reasonableness review operates on a spectrum from light form rationality review to more intense proportionality scrutiny. And thus it would seem to be well suited as a review standard where you acknowledge that the primary role to recognize, to give effect to socio-economic rights lies with the legislature and executive. However, as I have argued in another context, despite its appeals arising from Enlightenment values to universal and objective reason, reasonableness as a legal standard is infused with a range of contextually contingent values, assumptions, and worldviews. It invites questions such as who's reasonable, whose reason, reasonable in relation to which standard, reasonable in what context, and without an account of the values, standards, and goals informing an evaluation of what constitutes reasonable conduct, reasonableness review is inherently malleable and unpredictable. But we have a normative standard specified in the Constitution. We don't need to search for it elsewhere. The text in sections 26.1 and 27.1 clearly gives us this normative standard, and that is the full realization of the substantive rights in these provisions: access to adequate housing, access to healthcare services, including reproductive healthcare, sufficient food and water, and social security, including, if they are unable to support themselves and their dependents, appropriate social assistance. What the court's jurisprudence has effectively done is it has completely minimized the role of the rights in providing the normative lodestar against which the reasonableness of the state's conduct is evaluated. The role of the first subsection of sections 26 and 27 has largely been confined to that of a negative duty, not to deprive people of their existing access to socio-economic rights. In relation to the positive duties imposed on the state, the court adopts a default attitude of deference towards how the legislature and executive have defined the content of these rights, intervening only when it deems the measures adopted to be unreasonable. But as we all know, the court has also set certain criteria of reasonableness. And the classic formulation by Justice O'Regan in the Mazibuko case is that there are three circumstances where government conduct, or indicators where government conduct, will be deemed unreasonable. That is, number one, when there is no provision for those in desperate need, a la the Grootboom case. Secondly, where there are unreasonable exclusions or restrictions of groups from the relevant programs. Examples here would be the TAC case, the Causa case, and the Mshlangu judgment. And thirdly, inflexible and rigid decision-making by government that is not responsive to scientific evidence or evolving circumstances. TAC and Mazibuko would be examples. But none of these indicators of reasonableness enable the court to evaluate whether indeed the state is making reasonable progress towards the full realization of the rights. This, despite the statement in the Grootboom judgment that a reasonable measure must be capable of facilitating the realization of the rights. So while the court has alluded in certain judgments, the Grootboom case being one, to some of the substantive elements, for example, of housing rights, and I fully agree with Justice Majid that the concept of spatial justice in the Tubachali case is a very positive substantive identifier of the factor of location of housing, which is also found in the UN Committee's jurisprudence. But none of these factors have really played a meaningful role in the reasonableness inquiry, and they tend to be delinked from the normative goal of achieving the full realization of socio-economic rights. We are left instead with a set of free-floating factors, what Dani Brunt has referred to as structural good governance standards, and the notion of progressive realization has simply been subsumed into the principle of reasonableness. And the consequence of this is that the situation of rights holders, their contextual circumstances, their particular justifications and perspectives can carry very little weight in the assessment of reasonableness. In fact, as Lucy Williams persuasively demonstrates in her article, which compares the Mazibuko judgment with a decision of the German Federal Constitutional Court, which cut back social security benefits for vulnerable people, the court has tended to be highly deferential in evaluating the evidence and the justifications provided by organs of state. Again, this does not imply that the court should usurp the policy-making role of the state, nor should it ignore reasonable evidence of resource constraints and rights-based priority setting in decisions impacting socio-economic rights. The ultimate aim should always be to get the state to justify its conduct in light of the substantive normative purposes of the rights, and to require them to put forward their evidence and justifications in support of their conduct. This is what I have described in my book as a substantive model of reasonableness review that is quite capable of respecting the state's primary policy-making role. This model would place the burden on the state to demonstrate that it is making reasonable progress towards the realization of the rights in accordance with a substantive participatory plan with indicators linked to the realization of the rights. For example, such plans should set goals and markers of progress in advancing the accessibility, availability, quality, equitable distribution, and ecological sustainability of socio-economic rights. These are indeed many of the criteria that the UN Committee uses under the Covenant on Economic, Social and Cultural Rights, which South Africa is a state party to. But I think what is needed in the way that Justice Majid did with the notion of spatial justice is we need a process of translation and localization to the South African context. So before I conclude, I want to say a word just about the phrase within available resources in sections 26.2 and 27.2. Does this killer phrase undermine any attempt to construct a more substantive model of reasonableness review? I don't believe this is necessarily the case, particularly if the courts are prepared to broaden their notion of what resources are available and to require proper justification from the state for decision-making impacting on the resource availability for socio-economic rights. The refrain that resources are too limited in South Africa to provide even a minimum core or basic level of social rights is a consistent theme in the jurisprudence and indeed much of contemporary media commentary. Thus, and to quote Justice Majied's extra-curial lecture, and I quote, "An economy devastated by the pandemic and the staggering looting of public resources just cannot cope with all the demands imposed by socio-economic rights based on a minimum core conception. And judges must be acutely mindful of that. The cake is small and getting smaller, but the demand for a slice is large and rapidly growing larger. However, and again with respect, Justice Majid, I think this obscures more than it illuminates. As the World Bank has recently pointed out, South Africa is the most unequal society in the world, with race playing a determining factor in a society where 10% of the population owns more than 80% of the wealth. The UN Committee on Economic and Social Rights, in its conclusively high levels of economic and social inequality, and that South Africa's fiscal policies were insufficiently progressive to generate the resources needed for socio-economic rights realization. It also expressed concern that austerity measures have resulted in deep cuts to the health, education, and other public sector budgets, and this would run the risk of further worsening inequalities in the enjoyment of these rights. So the levels of income and wealth inequality in South Africa highlight that the issue is not that the cake is too small, but that the slices thereof are very unevenly sliced and not distributed in line with constitutional priorities. So the inevitable rejoinder, I anticipate, is that courts cannot and should not get involved in dictating on the desirability of government's macroeconomic or budgetary policies. These questions are quintessentially within the purview of the executive and legislature, given their institutional legitimacy and expertise in this area. However, once again, we are not presented with a binary choice, a totally hands-off role to the judiciary whenever the state tolls the bell of scarce resources, or the judiciary micromanaging and second-guessing the government's economic and budgetary policies. There are already many positive precedents in the court's jurisprudence that it could build on. For example, in the Blue Moonlight judgment, the Constitutional Court required the city of Johannesburg to provide evidence as to its overall budgetary situation to support its contention that it did not have the resources to provide emergency accommodation to those evicted from private accommodation. As the court held, and I quote, "This court's determination of the reasonableness of measures within available resources cannot be restricted by budgetary and other decisions that may well have resulted from a mistaken understanding of its constitutional and statutory obligations. In other words, it is not good enough for the city to state that it has not budgeted for something, if it should indeed have planned and budgeted for it in the fulfillment of its obligations." So again, I feel that the state and the organs should be called upon also in the sphere of the resource allocation decisions to justify that they are making budgetary and macroeconomic decisions in line with the substantive and procedural criteria of reasonableness review. One of the important procedural criteria in this regard is that there should be opportunities for meaningful participation by the public in resource allocation decisions. It's only with meaningful participation that one can appreciate the impact of rights on various groups. And I think here there is much potential in the meaningful engagement jurisprudence of the Constitutional Courts. So in short, for the judiciary to interpret socio-economic rights in a way that allows the state to evade accountability for socio-economic rights by simply not allocating sufficient funding for the particular rights is, in my view, contrary to the doctrine of constitutional supremacy, not in line with the text of sections 26.2 and 27.2, nor consistent with South Africa's international obligations. So to conclude, South Africa has had a brutal history of conquest, dispossession, discrimination, and exploitation. The Constitution is undoubtedly an imperfect product of political negotiations and compromises. For many of our fellow South Africans, these compromises and the persistence of racially based patterns of poverty and inequality have led to constitutional skepticism, or even for some a call for constitutional abolitionism. I do not believe the Constitution should be valorized, nor that the court's role in advancing fundamental economic and social transformation should be overstated. However, the reality is that every day the ordinary courts of law in this country act robustly to protect property rights, freedom of contract, and inheritance rights. These are the rights that largely, not exclusively, regulate the transactions and protect those that currently have income, assets, and inherited wealth. Is it too much to expect of our courts to act more robustly in defense and promotion of the rights of those who are excluded from the socio-economic underpinnings of a dignified life? The socio-economic rights in the Constitution clearly give the courts this mandate. My argument is that the Constitutional Court should reverse their current interpretive trajectory, which weakens this mandate. This will not in and of itself transform our society and the economy, but it can help to create a legal system that is more responsive to the voices and struggles of those facing social and economic exclusion and injustice. I believe that this is a modest but crucial contribution to South Africa's quest for transformative justice. Thank you.
Thank you, Sandy. I'm going to give over to David immediately and say something about that wonderful lecture after David has spoken, but it's exactly what I had in mind. Thank you. I'll say it at my own expense.
Good evening, everyone. It's good to be with you, and I would like to first start by thanking Justice Majiedt for the invitation to deliver this lecture. You very much follow in the footsteps of Justice Lange, because I wrote my first book, Poverty and Fundamental Rights, which I have over here, and Justice Lange wrote the foreword. And despite it being highly critical of the Constitutional Court, he said this is exactly what we need in South African democracy. And so thank you for the invitation, Justice Majid. As Professor Liebenberg has done, I will follow suit in being rather critical, but at the same time, it's friendly criticism, because ultimately we are in this joint project together of trying to improve our political community. I would also like to thank Professor De Vil and Ebenezer from the Dullah Omar Institute and Gladys and for the invitation as well, and for the hospitality here, and also it's a great honor to share the podium with my friend and colleague, Professor Liebenberg, who is one of the leading lights in the world and was in fact the vice chair of the committee she mentioned of the United Nations Committee on Economic, Social and Cultural Rights. So I'm going to start, let's see if this actually works. So I've got slides. So I'm going to start with two stories. The first is about Bongani, who is someone I see almost every day on the way to work. Bongani stands looking forlorn at one of the many traffic lights in Johannesburg. Bongani appears not to have clothes and simply to wear a blanket to shield him from the elements. He looks emaciated and has told me that he feels cold all the time, a strong indication of malnutrition. Bongani has nowhere fixed to sleep, and he finds himself usually sleeping in a nearby park. He mentions how he is continually in fear of his life. He had to leave school early to ask for money on the streets, as he had no food. And he tells me that there are no jobs, and that in his situation, without being able to wash and living simply with a blanket, that no one is willing to employ him. So the first question I want to ask you, what is wrong with the plight of Bongani? You might think it seems rather obvious, but I want to suggest to you what the intuitive answer is, and I want you to start thinking about this in relation to what the Constitutional Court says is the problem with Bongani. Bongani lacks the basic necessities to live. His plight leads his survival to be threatened. He lacks basic shelter, basic food, and clothes. He is in a state of physical and mental desperation, living day to day with no hope for the future. He cannot access social assistance because he lacks a birth certificate and does not have an ID, and he suspects he may have been born to foreign parents. And we think that no one should be allowed to live in such a desperate situation in South Africa. I'm now going to tell you another story of Nokuthula. Nokuthula lives in an informal settlement near Orange Farm and is on the waiting list for an RDP house. She has constructed a shack and managed to ensure it does not leak when it rains. It is too small for her and her child, but provides her with shelter from the elements. She has a standpipe within 100 meters of her house, which is the government standard, and a new government-installed toilet. Nokuthula accesses the Social Relief in Distress grant and buys cheap but functional clothing. She would like more money to buy warmer clothing as well for the winter. She is only able to eat twice a day, but tries to prepare healthy food for herself and her child. Her child goes to school, though she's not very happy with the quality of education that the child receives. What's wrong with the state of Nokuthula? Well, she has protection from the elements, but her house is too small and not made of very sturdy materials. It does not afford her adequate privacy or space or enough security. She has limited income and cannot afford sufficiently warm clothing. She also cannot afford 3 meals a day. And her child's education is not of a good quality. Now, I want to look at the two cases against one another, Bongani and Nokuthula. Bongani is malnourished, exposed to the elements, and has no shelter. Bongani can't access social assistance, and Bongani does not have clothes. On the other hand, Nokuthula has 2 meals a day. She has shelter from the elements, though it's inadequate. And Nokuthula has access to a SROD grant, a Social Relief in Distress grant, and she can afford clothes for herself and her child. Now, I imagine many of these stories are recognizable to you, and we're often going to speak in the abstract language of the law, as I will be doing for the rest of this presentation. But it's important to remember that these abstractions relate to concrete lives of individuals and their suffering and their plight. And they also highlight why we object to the situation of these individuals. We should always test our theories and intuitions against what they mean concretely for people like Bongani and Nokuthula. And courts should consider and engage with the position of these people and not simply sit in an ivory tower. We should also challenge theoretical abstractions that do not adequately address the issues raised in these stories. I would suggest to you these stories provide the foundation for our discussion. They illustrate concretely a number of points. We care about the plight of individuals such as Bongani and Nokuthula. Both lack the resources necessary to live a fully decent life in South Africa. We can make judgments that the position of some people, like Bongani, are in a state of more urgent need than other people, Nokuthula. But we can also recognize that neither is in a state we believe individuals should live in South Africa. And these ideas help us to understand some of the important questions that we will be discussing today. The core part of my argument, and it has some overlap with what you heard from Professor Liebenberg, is that it is the duty of the Constitutional Court to give effect to the fact that socio-economic rights are fundamental rights. And the Constitutional Court is thus far failing miserably to give effect to the transformative power of those rights through its reasonableness approach. The conservative judicial culture, which was predicted by Carl Clare in an early article in 98 of our order, is stunting the possibilities of these rights. And only by shifting gear and recognize that these are true rights can their potential be achieved. I'm going to look at a particular understanding of how these rights can be rights, which is known as the minimum core approach. And the way I'm going to structure this is tell you a little bit about the minimum core approach, because we have to understand it first. And then I'm going to engage with many of the critiques that were lodged in Judge Majid's lecture a couple of months ago. And because of time, I can't be exhaustive, but I'm going to focus on issues that are most salient. In relation to the first critique, Judge Majid says that the minimum core approach doesn't adequately address the language of the Constitution. I'm not going to address that, but there is a full response, and actually Professor Liebenberg has sort of laid out some of the background of that response, but I'm not going to go into that in detail for time reasons. The criticisms 2 is that the right must be defined in relation to available resources, and I won't go through them because I'm going to tell you all about them as we go along. Criticism 6 as well, which is that it is against the role of judges, I will also not address so much because you've also heard quite a bit from Professor Liebenberg about the way in which and what the respective role of judges is. So what is the minimum core approach to socioeconomic rights? Well, let's start with the beginning of what Judge Majid says in his lecture on socioeconomic rights, and he starts by saying there is hardly any difference between socioeconomic rights and civil and political rights, and that the differentiation between them is more apparent than real. Now, I agree with Judge Majid in this respect, but my problem is that the rest of the learned judge's lecture effectively seeks to emphasize the differences between the two types of rights and why, in fact, socioeconomic rights are not full fundamental rights. And so the starting point must be to understand that socioeconomic rights and civil and political rights are both fundamental rights. And why? Where are they rooted? Well, you've heard a little bit from Professor Liebenberg about the justification. I'm going to go through this very briefly, okay, because we can spend a course on it. But ultimately, I'm going to take the value of dignity, of worth, that every individual has worth. And if an individual has worth, they need to be treated in accordance with that worth or intrinsic value. And what does it mean to treat someone in accordance with this worth? Well, basically, we have to recognize that individuals have certain fundamental interests in freedom to live their lives according to the way they wish, and they need certain resources in order to live a decent life. And so to treat an individual with dignity or respect for their intrinsic value requires treating them with respect for the entitlements that protect those fundamental interests. It's a basic argument for fundamental rights. Okay? So consider a government that throws someone in prison who criticizes its policies. Individuals with worth have an interest in having their views heard and respected. Failing to accord those views respect shows disrespect for their worth, as does depriving them of their liberty. Dignity, moreover, requires respect such that people do not live in a state of destitution. People like Bongani, who are left starving on the streets, are not treated in accordance with their worth. Socioeconomic rights are entitlements that individuals have by virtue of having dignity or worth, to be provided with certain resources or capabilities necessary to live a decent life. And the important point here is the source of civil and political rights and socioeconomic rights are the same. They're rooted in the fact that we must treat every individual with respect for their dignity, and that requires giving them and respecting their entitlements. Now, it is often said that in relation to socioeconomic rights, there is a real need for a high amount of resources, such as in relation to food or housing, and so many people say there are specific worries that arise in this area. First, there is a large amount of need, with millions lacking what the Constitution promises them. And second, there is a limit to the resources available to provide for that large need. And thirdly, there is a lack of capacity on the part of the state to provide them with this need. I'm actually not going to deal with the capacity issue, okay, but I think it's absolutely critical in South Africa we start thinking more about the capacity question. But I'm going to focus on the need and resources dynamic. And to address this dynamic, the UN Committee on Economic, Social, and Cultural Rights introduced something called the minimum core approach. The minimum core approach says that the state must provide minimum essential levels of each right, and that the state must satisfy as a matter of priority its minimum core obligations. The higher level of the rights must be realized progressively over time. And the lack of clarity by the Committee on Economic, Social, and Cultural Rights and in its general comments as to exactly what this approach entailed partly led to my book that I wrote on poverty and fundamental rights and some other developments of this concept by other authors to try and understand a little bit more of what it means. So what is the justification for the minimum core approach? It is rooted in the idea that there are different levels of a right, and that we need certain goods to live certain lives of value to us, and that there's different degrees of urgency to the interests involved. And what is urgency? Urgency relates to the greater impact that a particular deprivation of a certain amount of goods will have on the ability of an individual to live a life of value to them. The minimum core provides a very strong protection for particularly urgent interests, and a very strong justification is required for failing to realize those interests. It creates a base from which rights must be developed, and it creates a claim for a certain level of resources for individuals, what we can call the first or most urgent threshold, and that baseline is the beginning from which the state has to build to a higher threshold, which I term the sufficiency or adequacy threshold. So let's illustrate this approach with a case in Colombia which effectively adopts the approach, called T25 of 2004. It's a case dealing with a massive problem of internally displaced people that was caused by huge conflict in Colombia. There were about 4 million people that resulted from 40 years of internal displacement. And after receiving hundreds of complaints, because in Colombia, individuals can reach the court if they lack certain goods, the Constitutional Court decided to bunch these together. And it declared that the situation relating to internally displaced people was a violation of their rights in a systemic manner, what it called an unconstitutional state of affairs. And the court said there that it will not always be possible to satisfy in a simultaneous manner and to the maximum possible level the positive obligations imposed by all the constitutional rights of the entire displaced population, given the material restrictions at hand. Nevertheless, a minimum level of the rights of the internally displaced people, the IDP on the slides, had to be protected immediately. These minimum levels, it defines as those that have a close connection with the preservation of life under elementary conditions of dignity as distinct and autonomous human beings. The court held importantly that it is there in the preservation of the most basic conditions that permit a dignified survival, where a clear limit must be drawn between the state obligations towards the displaced population of imperative and urgent compliance, and those which, even though they must be fulfilled, do not have the same priority. And this reasoning was then used to identify a range of minimum rights, including life, a basic level of subsistence, essential medical services, and sanitation that had to be provided as a matter of urgency by the state to these internally displaced people. So the case illustrates the main characteristics of the minimum core approach. There are different levels of urgency of interests. There's the inability to achieve a full realization of rights immediately. There are resource constraints, and one must give priority to the most urgent levels, but there's also an obligation to move beyond those urgent levels progressively. And so it creates a baseline from which a higher level of provision is built. And so we have an identification of different thresholds and a stringent obligation to achieve the first of these. So now you've got a bit of a picture of what the minimum core approach means. Let's move to some of the objections that have been made to the approach. Now, Judge Majid, in his second objection, as I said, I'm not going to deal with the language one, asks if the minimum core is absolute, identical between states, or relative, determined by states' resources. Now, I'm actually going to disentangle this question, and I'm actually going to move it later on to the absolute relative question a little bit later on. But I'm interested particularly in what Judge Majid goes on to say, as that he says that in fulfilling socioeconomic rights, there is a constant tension between needs and resources. The problem, he says, is that needs are immediate and large, and the availability of resources is limited. As a result, he concludes, we need to define rights in relation to available resources. That's the claim I want to put under the microscope. Defining rights in relation to available resources. And let's us consider this in relation to a famous case, the Subramani case. Mr. Subramani suffered from chronic kidney failure. He claimed an entitlement to treatment that addresses it, called kidney dialysis by the state, as he could not afford it. Here's a picture of kidney dialysis. There were a limited number of dialysis machines, and the state had adopted a policy that only those people who had acute renal failure or were eligible for a kidney transplant could get kidney dialysis. And Mr. Subramani did not fall in these categories. And so he initially could afford to pay for it, and then eventually he could not. And he asked for it at state expense. And he was denied it, and he challenged the policy as a violation of his right to have access to healthcare services. And the court dismissed Mr. Subramani's argument. And it said that he could not claim a right to kidney dialysis in terms of Section 27(1)(a) of the South African Constitution. And I want you to see what it says over here. It says, what is apparent from these provisions is that the obligations imposed on the state by Section 26 and 27 in regard to access to housing, healthcare, food, water, and social security are dependent upon the resources available for such purposes, and that the corresponding rights themselves are limited by the reason of the lack of resources. So the lack of resources, to understand that, meant that Mr. Subramani never had a right to kidney dialysis and therefore could not claim it. And so it defines the right in relation to the resources that were available. What's wrong with Mr. Subramani? It may not have been possible to provide everyone with kidney dialysis, but the court renders rights conditional on resources. It finds that there was no violation of Mr. Subramani's right. And this was a case literally where constitutional court judges had power of life and death. Mr. Subramani died 4 days after the court decision. This seems to me to be fundamentally wrong for the reasons I'm going on to specify. The first is that Judge Majid is right in one respect. The minimum core approach, or any other approach that regards socioeconomic rights as rights, would have to be able to define the content of the right without reference to resources. Okay? Why? Well, we've already addressed why that's the case. Because socioeconomic rights are entitlements that flow from the intrinsic value of a person. In a society that protects the worth, or that worth, everyone is entitled to adequate housing, food, water, healthcare, irrespective of whether there is resources to provide them. If Mr. Subramani has dignity, then his entitlement to healthcare did not disappear because it was expensive and the state resources were limited. And related to this is another important argument. If rights are simply dependent on present resource availability, then we can simply say that the status quo adequately fulfills rights. But rights are meant to show us what's problematic about the status quo. Right? The award-winning Nobel economist and philosopher Amartya Sen says the following: proclamations of human rights are to be seen as articulations of ethical demands. To see the ethical force of some claims is also a demand to consider what one should do to make them realizable. For example, through working for the development of new institutions. So let's take an example. Many of you will have been following what's been happening with the very brave women in Iran, who have been demanding basic freedom and the right to choose whether to wear a head covering or not. We know of the terrible consequences meted out on one young woman, Mahsa Amini, for failing to do so. She was literally beaten and died. Applied to civil and political rights, Judge Majid's principle would seem to imply that one only has rights if the conditions for the rights realization are there, are available. This would mean that women in Iran lack any fundamental rights because the theocratic government refuses to grant them such rights. That allows rights simply to appear and to disappear based upon whether there are ripe conditions for their realization. That seems to be a complete mischaracterization of what rights in fact mean. Let's apply this by analogy to socio-economic rights. The learned judge's principle seems to imply that rights simply disappear from an individual where there is a current lack of resources to realize them. So a dying man like Mr. Subramani has no right to health care if the government cannot provide it. Similarly, individuals like Bongani and Nokutula cannot claim any right to better their position, given the fiscus cannot currently afford it. This approach, as you can see, I think mischaracterizes the very nature of rights as ethical demands which demand our attention and realization. It reduces us to accepting an unacceptable status quo. Rights instead flow from the fundamental dignity of individuals. They apply irrespective of whether the conditions are ripe for their realizations. Rights must spur us onto action, to encourage us to change the status quo, to ensure that these rights are fulfilled. Rights are, as I've argued in a past paper, a bridge between our ideals and the world of reality. So, how does this all relate to the minimum core? Well, I hope you agree with me that rights should not be defined in relation to the availability of resources or their conditions for realization. At the same time, an attractive approach to rights cannot ignore the problem of limited resources. And that's why the minimum core comes into being, because the very point of the minimum core approach is to be able to partially realize the right for everyone, pending its full realization. In the absence of the capacity to fully realize a right, it is necessary to work out what aspects can be fulfilled and what aspects cannot be fulfilled. The minimum core approach is developed precisely to address the tension between needs and resources. So what then is the principle upon which we prioritize and in which we define urgency? That is the source of the third objection of Justice Majid. Now, the learned judge mentions a conceptual difficulty, that there is a lack of specificity required around how to define the minimum core. He quotes an article by Karen Lehman, who states that no principled basis exists on which the court can rank the interests of claimants when their interests are incommensurable. The judge contends that the courts are faced with hard choices of competing fundamental rights, and that making these hard choices is not assisted by the vague, unclear principles advocated by the minimum core lobby. He moreover states that the South African economy cannot cope with all the demands imposed by socio-economic rights based on a minimum core conception. Now, this criticism links with a number of points made in the academic literature and claims that the minimum core purports to give clear content to socio-economic rights, but it doesn't in fact succeed in doing so. And there are various reasons for this. Catherine Young, for example, in a well-known article, suggests that the concept conflates a range of different matters. She analyzes these dimensions, and she suggests that none of these is a wholly defensible view of the core. Others try and take some of the suggested content for the core and critique how the threshold is conceived. Now, I'm going to suggest to you, as a defender of it, that much of this criticism is misconceived. I cannot go in here. I actually did, as part of the paper for this, writing about some of the particular thresholds, but we don't have time to go into particular aspects. At this point, I want to focus on the reasons for the minimum core approach and why this is not actually a convincing objection. I will focus on emphasizing that what we want to do is retain certain entitlements that individuals have, even in a context where it is not possible to achieve the full realization of their rights. The minimum threshold ensures that individuals can have at least access to the most urgent requirements, whilst the less urgent but still important needs are being attended to. So what kind of standards should courts develop? The first thing that's important to recognize is that one must distinguish between the standard that must be fulfilled and the methods that can be adopted to achieve the standard. So let's think about the right to vote. Courts generally will set a standard that the government must guarantee the secrecy of the ballot. That's a standard. However, there are different ways of doing that. You could use a secure computer system or the traditional ballot box, okay? That is for the legislature and executive to operationalize, and we can actually look at whether they've adopted a reasonable approach, this is where reasonableness comes in, to achieve the standard. But you have a standard to assess whether or not the mechanism is in fact an acceptable mechanism. Similarly, the minimum core sets a universal standard requiring the government to provide accommodation that provides, let's say, protection from the elements in sanitary conditions with access to basic services. That's in relation to the right to housing. Okay, I'll say that again. Provide accommodation that provides protection from the elements in sanitary conditions with access to basic services. What are the concrete methods of doing that? Well, protection from the elements could be in galvanized iron tents, brick buildings, or flats. There are measures against, you need to test those methods against the general principles and the general standard that's set for determining whether those are acceptable means to achieve the standard. And there's a discretion for the legislature and executive to realize that in their own way. And so you see again here some division between what the courts must do and what the other branches of government must do. That still raises then the question of what standards should be developed. Now, I've before in my own work defended the idea of focusing the minimum core on survival. Survival is a very basic standard, but without surviving, every other right becomes entirely theoretical. Survival is the essential precondition to enjoying any rights at all. Thus, it is a very natural candidate to provide us with a hard minimum level that individuals must be guaranteed. However, other courts around the world have taken a slightly more expansive view. The Colombian court, as you saw, talked about there being a close connection with the preservation of life under elementary conditions of dignity as distinct and autonomous human beings. And so here the Colombian court defines the minimum as life plus dignity and autonomy. Okay? That's its minimum. The German court, in the decision that Professor Liebenberg mentioned on reduction of welfare benefits, asks the question, defines the minimum as what is vital to an existence that is in line with human dignity, and it includes physical existence as well as the minimum levels of participation in social, cultural, and political life. So in other words, it defines the standard in relation to dignity plus participation. Now, as I said to you, we can come up and discuss various questions about each one of these, but ultimately, the Constitutional Court is the highest court of the land and has the power to define the content of the right. And importantly, it does that in relation to other rights in our society. So just one example, the right to privacy. I've just got here an old case of Bernstein versus Bester. Here the court tells us we have a very intimate sphere of core element of privacy in the home, which needs a very high level of justification to interfere with. And as we move out into a more social dimension or social context, we have a more attenuated interest in privacy, and therefore it becomes easier to justify. So in relation to privacy, the court seems to have no problem defining a core and less urgent interests. And so I ask you, why is it so difficult for them to do something similar in the case of socioeconomic rights? Why have they been content to leave these rights simply undefined? It suggests again in some sense that there is a lack of recognition that socioeconomic rights are true entitlements that the Constitutional Court must give effect to. The court can opt for a minimal standard such as survival, or even a slightly more ambitious one, such as that adopted by the German court. It is simply not true that it is impossible to define such a standard. And no doubt any standard could also be refined over time throughout case law, as happens in other cases. What I think is highly problematic is the refusal to engage with this question and ultimately simply to accept that individuals must wait their turn for provision no matter how desperate they are and how unresponsive the state is to their needs. Let's come to the question of absolute and relative. The judge raises the question whether the minimum core is the same in South Africa, struggling to deal with a legacy of past injustice and exclusion, and whether it's different from that in Germany, which is now, also has a history of a very difficult history, but is now a wealthy liberal democracy. Judge Majid says the minimum core must be absolute, otherwise it would depend on resources and not be differentiated from reasonableness. Absolutism, he says, means that there is an innate, rigid, universal set of entitlements within housing, representing the minimum each individual requires to lead a dignified life, to be determined quite regardless of the state's available resources. Now, I've already argued to you why I think that rights should not be determined on the basis of available resources. But is the minimum core relative or absolute? The answer is that there is no need for an either-or. It can, in fact, be both. Let's take the first idea, that there is a universally applicable standard that one must be free from general threats to survival. We may say that this is in some sense an absolute standard of the minimum, but even in relation to that absolute standard, there are a range of relative dimensions. In order to have the shelter necessary to survive in a cold part of this country, one will need shelter that protects from the cold and hypothermia. If you are in a very warm part of South Africa, one will need shelter to help you protect you from heat, sunstroke, and dehydration. The standard guides what is required, but there will be a degree of relativity in the application of the standard. And it is simply not the case that any standard just applies in an invariant way, irrespective of differences between individuals and regions. Actually, to achieve a standard, one has to take account of relative differences between people and countries. There is another type of relativity, however, which may enter into the definition of a minimum threshold. We may decide in South Africa that it is not enough simply to enable people as an urgent matter to have the resources necessary to survive. But we want everyone to be able to live a life of full dignity in the South African community. Now, the level of dignity that's understood in South Africa may in fact be different to Germany, and perhaps be a lower level of resources. Doing so goes beyond the survival level and would require deciding, for instance, what in South Africa is required to live a life of dignity as we understand it. And that might involve aspects not limited to basic necessities, such as having enough money to be able to communicate via a mobile phone, have access to a television, and be able to attend important life cycle events like weddings and funerals. We might call this a relative minimum threshold, which defines for the South African community what we regard as the minimum level that any individual should have in the society. And there's no problem for the Constitutional Court to adopt such a relative minimum threshold. The standard might be higher than the pure survival standard, but would help deliver content to socio-economic rights and allow other branches of government to define exactly what constitutes such a social minimum. In fact, in other parts of the world, there is a lot of empirical research into deciding exactly what constitutes the minimum acceptable level of provision or basket of goods in particular societies that people should be entitled to, which is often known as the social minimum. Once again, the Constitutional Court has the power to define this in general terms for South Africa, which can then be left to other branches to realize. There is no reason why it needs to define the absolute minimum at the international level, which is not, in fact, its role. Now, there is a fifth objection, but we don't really have time because I want to enable us to have some discussion. So I'm going to go through those and jump to my concluding remarks. As the learned judge outlined, the Constitutional Court was in fact faced with a very difficult task of giving effect to socio-economic rights, whilst recognizing limited resources in South Africa. It is perhaps understandable that in the early days of the court, when I was a law clerk, that the court felt the need to tread a little bit carefully in the area of socio-economic rights, which was still developing. Unfortunately, the court has raised the doctrine of reasonableness into a dogma and seems intent upon going down that route no matter how unsatisfactory it is. The deeper conceptual flaws have been outlined by Professor Liebenberg and myself and other academics. But as I've sought to show throughout this talk, the courts have effectively neutered socioeconomic rights, rendering them not really rights at all. And I'm also going to skip through my discussion of the Tubachale case and the similarities I regard between the majority and the minority judgments. A very strong reason to jettison the approach of the court is to recognize that the results is the results that it is having on the jurisprudence surrounding socioeconomic rights. After 27 years, we only still have a handful of cases relating to the actual obligations of the government positively to assist in the realization of socioeconomic rights. This is in a country where there is grinding poverty, people literally lack the basic needs to survive, and there is widespread dysfunction in government. From my own experience of trying to bring a case with several NGOs about a universal grant to provide individuals with a minimum means of living, the reasonableness approach has made it incredibly difficult for NGOs and individuals to bring cases around socioeconomic rights. The level of evidence you have to show the government's being unreasonable, etc., is incredibly difficult to show. It is no use saying, as the judge quotes Maurice Pieterse, that rights act slowly. Whilst rights have long-term effects, the reality is that rights often can act very quickly if I acquire an interdict to protect certain rights. For people dying on the streets of the cold, like Bongani, it is almost a mockery to say to them that rights act slowly. Why is it that we think socioeconomic rights can be indefinitely postponed in terms of their realization? If they are indeed rights and of an equal nature to civil and political rights, a change of tack must take place. In this talk, I've considered several critiques lodged by the learned judge, and I've tried to show you why none of these critiques is convincing or a good reason to jettison the main ideas behind the minimum call. It has also helped us to understand the attractions of the idea. We now see increasing need and greater government dysfunction and scarcity. In this context, the Constitutional Court must, in my view, change tack and fulfill the role the Constitution has placed upon it to defend socioeconomic rights as rights. The Court may find it unpalatable simply to jettison the reasonableness approach, but it is quite possible to integrate features of the minimum core approach within the reasonableness view. Professor Liebenberg has defended a version of that. One could argue Grootboom, in fact, did that, and in fact, in countries like Mexico, they have sought to do that. The court needs to stop avoiding recognizing what socioeconomic rights are for, namely to protect the most basic interests of individuals to certain resources. It should also be prepared to recognize that prioritization will be needed and to engage with the principles on which one must prioritize. In doing so, it can draw on the learnings of other courts and academic authors of what would be the best principles and basis on which to prioritize. The doctrinal issues around the minimum core are not the only facets that will be necessary to improve performance in this area. The reality is that we need a better system for accessing justice for poor people in the context of socioeconomic rights. And we should grapple with how this can be done so that, like in places like Colombia, individuals can in fact challenge the deprivation of these rights. That requires attending carefully to our institutional structures, the Public Protector, the South African Human Rights Commission, and the expansion of access to courts. We in fact need many, many more judges in this country. The Constitution included socioeconomic rights for a reason. It recognized that they were universal entitlements to live a decent life And it also recognized that they were absolutely necessary to correct for many of the injustices of the past. The Constitutional Court needs to seriously rethink its current approach to give effect to socio-economic rights. In doing so, I hope it will ensure that these rights are not merely paper promises, but actually demonstrate to those who are least well off that South African democracy and political community will not accept the existing situation where individuals like Bongani are simply left to die naked on the streets of hypothermia and to perish from starvation and thirst. Thank you.
Thank you, David. I mean, you've listened to excellent presentations, and I was sitting there and thinking that, I mean, I invited these people here, especially David, and this is what I get. And I thought the only redeeming feature is that minority judgment into Bakale. If it hadn't been for that, I would have been torn to pieces this evening. But in all seriousness, I think this, as I was writing to Bakale, this is exactly what came up to me is, which way are we heading with socio-economic rights enforcement in this country? Given the history that started with Grootboom, Subramani, the careful treading, then Mazibuko, and so on. And so this is exactly what I thought we should discuss, is really the way forward. And because I am where I am, wearing my hat as a Constitutional Court Justice, I won't say anything either way, except to say that I think I've said the scene in my inaugural lecture, and you've heard the other side of the scene. And what is key is that Professor Liebenberg emphasized the question of reasonableness, the question of within available resources. Are those necessarily insurmountable constraints, as the court seems to suggest in its earlier jurisprudence, and which way should we head with that? And she also set for us the history behind this approach to socio-economic rights with the Congress movement and even the Black consciousness movements, like, or the PAC at least, having that same kind of philosophical insight into this. And then David has strikingly illustrated for us why the minimum core can work. And when I presented my paper, of course, I did it wearing my hat as a Constitutional Court Justice, but also to stimulate the debate about whether minimum core, as the court I've previously said, especially in Mazibuko, is a difficult concept, and the court firmly rejects it. It's not cast in stone, because as I said to the students this morning, we must remember that a constitution and constitutionalism is dynamic. It evolves all the time. It must move with the times. And the question has come, as we look at socio-economic rights litigation, David is absolutely correct. Why are there so few cases? And why has the court been almost a sort of inertia? Now, judges by nature are conservative, and this morning I spoke to one, this afternoon too, about the undergrad classes about separation of powers, judicial deference, and just and equitable relief in Section 172 and in Pajan Section 8. And so when you counterbalance all of that, where does it leave a judge who must sit and decide on questions of socio-economic rights? The person is hungry and cold in the corner of the street, Bongani, and Lokotula doesn't have adequate shelter, and the children are not getting adequate education. How do you, as a court, while staying in your lane, because I think it's important for us to stay in our lanes, we realize those socio-economic rights, because ultimately the buck stops with us. You see, our difficulty in the court, and I'm not trying to defend the court, but the court is mindful that at this time in the history in South Africa, arguably the other arms of government have either failed or are failing. And therefore, on the third arm of government, there's increasing pressure to make up for those failings. And when we discuss this, we must discuss it objectively on the basis that let's assume a fully functional legislature, executive, and where's the judiciary. We mustn't say because these are crisis times, and therefore we need your guys to get out of your lane and forget about separation of powers. We must still remember that somebody once said, one of my colleagues, and I mentioned this to the students this morning, said, the president has got extensive powers in the Constitution, and some people say it was written as if Mr. Mandela will always be our president. And when you write a constitution, you must write it on a worst case scenario basis. And we must be careful that when we do this debate, we mustn't do it on the basis that South Africa is a failing state and therefore the judiciary must do the work, just to put it bluntly, of the other arms of government. So let's engage this discussion. I must say, for me, as a pseudo wannabe honorary academic, but who must decide the hard cases which will have binding precedent, it's very illuminating to hear eminent proponents like Sandy and David speak. I mean, as I say again, you've been treated to 2 excellent lectures. And I think it sets the basis for us to move forward and to say, when we get to 14 August, to hear how Johan Vroneman from a retired justice position and Nomzamo Zondo from a SERI NGO position build on all of this. That I have the little that I've done, but the much bigger work than they've done this evening. But let's engage in discussion with this evening's 2 papers, and which again I'd like you to ask to give them a warm round of applause. It's been terrific. So I'm going to sit here and field questions. Please identify yourself, and then you ask your question, and I'll hand over to them. We've got mics here. I'm going to switch mine off. I think we've got the technician here. Oh, you're going to take it up, yeah. Thanks. So I think what we'll do is, depending on who you ask the questions for, if you have 1 or 2 or more questions, let's get a few of them grouped together. Not really deal with the answer.
Thank you. I'm Kaushik Sundararajan from the University of Chicago. Professor Bilchitz, this is a question for you. I'm fully on board with the spirit of your talk, and so what I wanted to do was ask a question that may be pushed at this question about concreteness, and pushing at it from the perspective not of the concreteness of individual suffering, but the concreteness of the sectoral specificities of political economy, and especially the political economy of healthcare, since you brought up Subramani, right? And so the difference between, say, something like electricity, which is a state-owned utility, or housing, which can be publicly provided, and many advanced medical therapies and technologies, is that the latter operates in extremely privatized and often monopolized spheres, right? So when one is talking about resource constraint, one is also talking about the tangible question of expense. And so a non-hypothetical here is, this summer, the first gene therapy for sickle cell anemia is about to be approved, right? Sickle cell is a huge burden of disease in Africa. A single therapy is going to cost $3 million, right? And there's no half measures there. There's no way to have half a gene therapy. So if you had a patient with sickle cell approach the Constitutional Court saying, I need a right to sickle cell therapy under conditions of minimum core, what do you do there? Because there the sort of tension is not just between individual dignity and the state's statement of resources, but individual dignity and a public burden on health, which I think was the rationale between the Madala-Sachs concurrence and Subramani, right? And and ironically then, potentially a minimum core might lead to slicing the case unequally again, right? Where an individual treatment directly impacts the availability of public. So how would you think through that kind of specific kind of sectoral problem having to do with expense in situations where the state does not have the capacity to set the price on the resource being allocated?
I think that's such an involved question. I think, David, would you like to answer it now?
Great. It's a really fascinating question. And I want to firstly challenge the notion that the parameters of price are, because one of the interesting things is, why is, when you're looking at something like Subramani, why is dialysis so expensive? Why is, I start my book that I've just, Professor Liebenberg invited me to talk at Stellenbosch, I'm talking on Wednesday, about my book on the obligations of business. And there's actually a similar drive for Herceptin, which is absolutely central in addressing breast cancer, which emerges from a BRCA gene. Why is it so expensive, right? And I don't think we can simply accept resource scarcity. And when we look at availability, accept the price as we give them the price. Okay? Why was the Pfizer vaccine initially so expensive? Right? Those are not fixed necessarily parameters. There are certain costs that are involved, but there is also a whole structure of marketplaces, a structure of patents, etc., which allows for very, very high level profiteering. And the question is, if we're going to talk about available resources, we actually talk about in some senses, well, why have we structured our marketplace in that way that we've allowed people literally to die because pharmaceutical companies make profits, right? And I think that's a central question that we have to ask. I'm not saying there's a simple solution, and I'm not necessarily even saying it's the answer that the Constitutional Court can address, because the problem is actually a global issue, and it's going to have to be addressed to some extent because we are part of the TRIPS agreement, all kinds of things in the WTO levels. It has to be engaged more at the global level, and the kind of exceptions that exist need to be utilized, right? And actually, South Africa's been reasonably weak in doing this, whereas some other developing countries like Brazil and India have been much stronger in challenging that. So the first question is price, and when we say the resources are not available, are they really not available? Are we dealing with absolute resource scarcity where we've run out of a resource, or is it humanly created scarcity? And once it becomes humanly created scarcity, we're in a realm where we need to think very, very carefully about the way in which we structure the marketplace and our access to certain goods, and we need to ask certain fundamental questions about that, which many people don't ask. They just say, well, that's the amount it costs. Okay? The question then is, what does the Constitutional Court do with that particular problem? They're now faced with the fact that there is a set price. They're not going to order a violation of patents, against WTO rules. What does it do? Right? And what would it do in Subramani? What would I want to have seen in Subramani? Right? So the first thing is the minimal core approach is not absolute about the minimum core. That's a very important point. Right? The minimum core approach says, right, that just like what you listen to in relation to privacy, right, that in relation to the home, there's a very stringent justification that's needed for the state to be involved in violating the core of the home. Now, where there's domestic violence in the home, the state can get involved because there's a very good justification for doing so, right? And so in relation to the minimum core, in relation to healthcare, right, I think survival, quality of life, these things still matter in relation to people, even when there's very expensive treatments involved, right? Those things don't disappear. The question then becomes, is there a justifiable reason for limiting the right? So the first thing is the court defined the way the right in Subramani, right? That's what I'm objecting to. The first thing is there must be an infringement of the right at least, right? Then we can start saying and looking at the justifications for the infringement and saying, well, was the policy of the government that was adopted in relation to dialysis a reasonable policy? The court again was incredibly deferent towards that, okay? And I think in a failing healthcare system, right, the access to healthcare in this country, right? I know someone very close to me with terminal cancer was given Panados to deal with the pain, right? So with that failing levels of healthcare in the system, surely there needs to be able to be considered challenges in this respect. And the court in Colombia has done incredible work in almost recasting the healthcare system in Colombia, right? To some people say to a better or lesser extent, but they've actually been seized with the problem. They see the issues that it faces people. And so we have to then look at and consider, are there good grounds for limiting the right? In the case of 1998 in relation to Mr. Subramani, probably it was beyond the capacity of the state to provide dialysis to everyone who needed it, right? So reluctantly, I don't know, but I probably would have agreed with the outcome, but the reasoning would have been different, and it would have also placed the duty of the government to continually revise its program so that it enhances progressively access to dialysis across the healthcare system. So it wouldn't simply say, well, there's no right to dialysis at all. It would be actually saying, well, look, we actually cannot provide it now, but we need to see a continuous improvement in access to services, and we want to and could have dialysis. So that's roughly the approach I would adopt.
Is this?
Yes. Sure. Thank.
Maybe I should The Colombian case is interesting because I, in preparation for this, did some research of my own about the minimum core concept. And it is interesting that Colombia, but also India as the global south, actually have adopted this approach, and in India also in the Delhi High Court in a case concerning drugs. And the courts there said that the court is of the view that core obligations under the right to health are non-derogable. And the minimum core is not easy to define, but it includes at least the minimum decencies of life consistent with human dignity. Now one could argue that resource-rich countries like the West could easily adopt this approach. But it's interesting to me that the Colombian court, in the case that David has mentioned, also in this Delhi case, has adopted the minimum core approach and has got me thinking about where we are heading in this country. I just wanted to add to that. Please, your question.
Sure. Thank you so much for the great lectures. I'm Tanveer Jiwa, currently at University of Stellenbosch. And Justice Majid, I'm sorry I addressed this question to you, but I'd love to hear what Prof. Bilchitz and Prof. Liebenberg have to say about this as well. Ever since Tubahale came out, there's one especially disturbing thing that I've been thinking about is why didn't the court consider a property argument? I know that you are constrained obviously by the arguments brought before you, but Merumotu, you're also allowed to consider specific issues. And I know that I can also ask the amazing Nomzamo why Seri brought forward certain arguments, but to me it was a lot of applicants were registered title holders, and a lot of them received municipal bills for places they didn't live with. And it speaks to the huge class discrepancy in keeping socioeconomic rights for black poor people. And then, as Prof. Liebenberg mentioned, we are very ready to protect contract and property rights, but for specific people, because these are property owners. And the fact that, to me, we run straight to eviction, Section 26.3, and not necessarily a Section 25.1 or 25.2 analysis is very telling. Because, I mean, to the worst set of fact, you point this out, Justice Majid, in your judgment, they've applied more than 20 years ago and they have been registered. It's almost pointing to the state failure of there's nothing left to do. Followed every procedure, they've applied for content. There's nothing they didn't do, and they're still not property owners. They're still applying for 26.3, and Justice Jafta says you should have evicted. In what capacity? Surely as a property owner. But then we leave that to be, and I'd just like to hear your thoughts. Thank you.
Well, I think primarily it's because of the way the way Seri presented the case. I mean, we're bound to the pleadings, and I mean, we can go beyond them, but I suspect it's because of the way we plead. But I mean, it's an excellent case. It's an excellent case to make out on property rights. I agree with you. I don't know if David or Sandy want to add anything to that. Nomzamo? And by the way, that case, as I understand, is back in the High Court now, I think, for contempt proceedings. We have been waiting for 9 months. That's the other side. Certainly, sorry.
there's a difference between, because you can have there's a difference between reasonableness and minimum core and individualized and programmatic enforcement of socioeconomic rights. And so I think you can have a program which essentially is based on the idea that you have a priority level, which then has to be brought over time. And what the debate in Colombia is about whether you should have individual access because they have this particular action that allows individuals to go to court quite quickly. I actually think that's a good for poor people, like to be able to access the court quite quickly and not have to create massive cases. And what I think the court in Colombia has done brilliantly is actually is bunch them together. So instead of saying we're going to decide one and one and one, they actually say, well, wait a second, we clearly got a problem in the healthcare system. Let us let's have a look at the healthcare system as a whole and consider the whole system around the healthcare and internally displaced people and prisons. There are a few of them that have done that in respect of. And I think that that's actually a good approach. But I think one of our issues, and we don't have the capacity at the moment with the way our court system is structured, individualized access. I've argued in another paper that actually our individualized access happens in some ways through the public protector and also through the Human Rights Commission. And I think if we're not going to make courts, we at the moment I think we have something like 250 judges in the whole country, right? In Colombia there are thousands of judges in the country. So what I think, if we're not going to expand our court system, then we have to expand access through those institutions to be able to challenge socioeconomic rights deprivations. Because imagine you're just the individual who's landed up with woefully inadequate healthcare or can't, is knocking at the door continually of the government and nothing happens, right? You just can't get your social relief and distress grant. What do you do? And I think that we have to have an answer for those people individually. And also just to say, in a way, the government, to some extent, has almost by default landed on the minimum core approach. I mean, I'm upset with the Constitutional Court for not pushing them in that direction a while ago. But what you see now is our president has recognized that you can't get rid of the social relief and distress grant. It was a big mess to take it away and the way in which they etc. and to after COVID and to reduce the number of people and the whole new system. But they've recognized that people are desperate and need a social relief and distress grant, and that is ultimately minimum core, providing people with a certain basic amount. And I believe there's discussions in the presidency of the type of universal basic income grant as well, which would also do a similar thing.
I was going to say there's 400 judges, but you probably say the way they work in England is only 250. You wonder what the other 150 is.
Are there 400? Good.
Yeah, more or less.
Not a lot.
I think
am I audible? Oh, yes. Good afternoon, Justice Majid and the learned professors. My name is Kuhle George, a final year LLB student and the chairperson of the Black Lawyers Association student chapter. My question is directed to all of you. And Professor Liebenberg correctly observed that central to the socio-economic dispensation is the commitment to address the injustices of the past. And amongst other things, what characterized the injustices of the past is the degradation of the African jurisprudence as a model of governing society and as a model of interpretation of the law. And my question to you, to all of you, and I've had this conversation before with Justice Majid, and we had it today in the morning. Why is it that the Constitutional Court is not using the African jurisprudence as a model of interpreting the socio-economic rights? And is it not one of the reasons why the Constitutional Court is failing to cure the socio-economic crisis in South Africa? The fact that the African jurisprudence does not find expression in interpreting the socio-economic rights of those who are colonial conquered, of those whose laws have been degraded by oppression. That's my question. Thank you.
Thank you. Good evening, Justice Majid. I do hope you are going to engage with that question. Difficult question, I should say. I have a number of concerns. The first one really, and this is, I think Professor Liebenberg and Professor Bilchitz can help me unpick this. I hear a lot of reference to available resources, but there is no discussion of what we are talking about when we say available resources. Which resources? Are we talking about the resources that are globally available to the country before the allocation of the budget? Are we talking about the resources that are generally there before the other resources leak due to corruption and mismanagement? Are we talking about the specific resources that are allocated to different departments? And my observation is that I do think that if we confine analysis to available resources to mean that what resources were you given by the national government to do one or two, that analysis is going to be really limited. And this is where I think Justice Majiedt is right to say that the size of the national cake is coming down and down. He's talking about the resources probably that are given to departments. Is that what the framers had in mind, just to limit that analysis to those resources? So that's the first concern. The second concern is I don't hear a lot from civil society, the academia, and even the courts about budget tracking and monitoring, because for you to actually be able to say in concrete terms, not in abstract terms, to say that you haven't done 1, 2, 3, you need to know what was allocated to what budgetary line items, to what specifically. Then you can say, okay, so you didn't do 1, 2, 3. Where did the money go? Without that, I think that sort of analysis, and I think civil society here can help, because you can employ experts that can follow up. Without that, I had the privilege to work at to study and work a bit at the University of Cape Town some years back, and Professor Richard Calland was doing a project where they were using the right of access to information to require municipalities to say, give us information, how much was committed to housing, how much was committed to water, and was that money actually used for that purpose? I think without that sort of information, our analysis has got some bit of limitations, and it's going to be very, very abstract. Then I do agree, I think, largely, absolutely with Prof. Bilchitz's observation that rights cannot be defined in terms of the resources that are available. I think the availability of resources just to play a role in the extent to which specific rights are then realized over time. But I wanted to say that I do hope, and this is my last comment, that we are very clear that it's a concern when judges say that the core is very difficult to define. I think it's a genuine concern that we may quickly dismiss. Just think about it. What does the right to housing exactly mean? Does it mean 2 rooms, 3 rooms? And what is the material that you are using to roof that? And in terms of the floor, are you putting tiles, floor tiles, or are you putting cement? And so I do think that there is some bit of concern there. And I do hope that we all understand that defining the minimum core actually will require the normative guidelines. This is not, for me, a job that the courts can fully do. You need to develop guidelines, say, on housing. And then you stipulate, okay, this is what the core is going to look like. So the court there, yes, I do hope that the consent has been heard, yes.
I just want to go quickly and say that comment put here on the court's lack of reference to African jurisprudence is absolutely spot on. And you and I have had this conversation. I just want to point that in a case, the African Commission on Human and People's Rights had to decide a case, a socio-economic rights action center in Nigeria, and they specifically recognized the minimum core in respect to the right to food. So this is something that's not unique. The minimum core concept is recognized even in our African communities. And just to come to your point, I think the simple answer is that is where the jurisprudence must evolve towards. Where the government department is as well as the lack of resources. I think, and again, I'm venturing maybe too far as a judge, but I should think that the time has come where you interrogate the budget, where you say, well, you've got to come and justify where you say we've spent the budget X, Y, Z. And my argument is that there's a point where you say the resources are not adequate, and yet you come and you need to come and justify why you've allowed corruption to flourish in your department and haven't taken any, so that the cake gets even smaller through malfeasance and corruption. And I think we are moving towards that point. That's all I can say, and I just want to say we've got to close this very shortly, so unfortunately we have to bring this to some sort of end. We're going to ask David and Sandy just to respond to you ask the questions.
Yeah, thanks very much. So just on the question on African jurisprudence, I wasn't clear if you meant like specifically South African indigenous or the African regional human rights system, but I think, there's absolutely invaluable resources that can be drawn on in both, concepts of participatory decision-making, concepts of solidarity. There's some really interesting cases. You mentioned one, Justice Majiedt, but also about protecting indigenous people's land rights in the Endorese decision and the Kenya decision. So I think more knowledge and deeper understanding of that is definitely, and that's sort of what I was talking about. You can have these abstract concepts, but they need to be localized to the African and South African, localized almost to our own context. And then just to add, Mark, exactly like what resources are available. That's what I sort of started off with saying. So the available resources can't possibly be the resources that government allocates to a particular line function, because if they allocated nil money, nil rands to the education budget, would that then be the available resources, or to housing and so forth? That can't possibly be that resources can dictate the extent of the realization of the right. So it's the UN committee interprets this concept not only, in terms of the defense for the state, but also requires the state proactively to show, justify what it's doing to mobilize resources. So through its fiscal policies, and through its trade policies, and also how it's preventing loss of resources, for example, through corruption or maladministration. So we have, those interpretations that can give us a much broader concept, but I agree with you, it's a big ask to expect the court to intervene directly in macroeconomic decisions, but I think what you were alluding to is there's so much work still to be done on the ground with budget tracking. The Human Rights Commission, I don't think, is doing what they should be with socio-economic rights and their specific mandate there, and also in developing deeper forms of participatory budgeting at local levels.
Yeah, thanks so very much for the questions. I'll add just a note on the African jurisprudence point. I took, when you say jurisprudence in a wider sense, not just about the actual decisions, but also about the thinking and about the philosophical approaches. And I would love to see more development by the Constitutional Court, because I think it's in a relatively unique position to root some of its thinking in number of others, and in our country, Ramose and various others. So I think it would be very good to see more of that tradition drawn on, and actually the courts can play a role in building on that tradition in some way. So I think that's obviously something hopefully we'll see over time built on. I think we've had kind of wider answers on available. I suppose I should just say I obviously agree with my colleagues. It can't be related to the budget per se. I've defined it as sort of the resources available to the state. But what are those? Right? So it's not it's obviously tax collection, but then there's much more than that, right? And there are cases where, like for example, during COVID-19, there's a good argument that the government may have had to borrow, right, to enable to feed people and sustain people, which it did. There may actually almost be an obligation to do that in certain cases, right? There's also the whole question, again, I raised this before, of the private sector resources that are available. I'm not talking about wholesale expropriation, but I'm saying there may be cases where private property rights, as I've suggested, need to, in some cases, be restricted. And the court has done that in some cases by saying, for example, you can't come into a property with people living in it and simply say, I'm going to throw people out, right? You may have the duty to be patient, etc., and to enable those people to have housing in the longer term. So that availability question is a much bigger question, and it puts us in that kind of wider realm of thinking about resources implicate the state, they implicate the state's embeddedness in a global order, and also the private sector as well in our country and elsewhere as well. And that leads, and that kind of led me very naturally to thinking about obligations of the private sector as well in relation to resources and what they have to do to enable the realization of rights. Something we have only just started thinking about, and I thought led the way kind of in Daniel's by rejecting the idea that private sector only has, or private individuals only have negative obligations, and opening the door to potentially for positive obligations. But then they went backwards and they said, well, in socio-economic rights, they can only have a negative obligation. So I hope we'll see that development also, that there will be positive obligations on the private sector. There has to be some restrictions. It's a complicated question, but I think it is a kind of really important question as well.
So thank you very much. I think they deserve a round of applause again before we close. As a token of our appreciation to our presenters, my colleague Gladys will just, on the behalf of the faculty and the Dullah Omar, we give you some very to appreciate you for wonderful work you've done. Thank you so much. So as that is going, I just want to thank our distinguished guest again, Justice Majid. We are very grateful. After 40 years of leaving the Faculty of Law here, you have remained in touch with us. And echoing the dean, you are one of the distinguished alumni of the faculty. So we're very grateful. Thank you for your support always. And the Liebenberg Prof, thank you a lot. You started the Socio-Economic Right Project at Dullah Omar, and you have remained in touch with us. You have supported and guided us. So thank you so much for your support all the time. Professor David Bilchitz, thank you so much all the way from Johannesburg to come and participate in this. We are ever so grateful. And to our participants, without you, this would not have taken place. So we are very grateful for you for staying behind. And we know that some of you, like Nozama, come all the way from Johannesburg to attend this. So thank you so much for coming. And we wish you safe trip back to wherever you are going. There's been a request that the dean and the a photograph just for record purposes. And then please, when you are leaving, you go through this. There's a gate there, and there's a light refreshment for you. So please, let's exit through that door. And so thank you, and wishing you all the best.